Hello, everyone, and welcome to our lessons on obligations under the Civil Code of the Philippines. So, we will be discussing in this presentation the general provisions. Under Article 1156 of the new Civil Code, which of course will define an obligation. Okay, so um, Article 1156. So, an obligation is a juridical necessity to give, to do, or not to do. So, obligation is derived from the Latin word obligatio, which means tying or binding. It is a tie or bond recognized by law by virtue of which one is bound in favor of another to render something. And this may consist in giving a thing, doing a certain act, or not doing a certain act. Article 1156 gives the Civil Code definition of obligation in its passive aspect. So it merely stresses the duty under the law of the debtor or obligor, meaning he who has the duty of giving, doing, or not doing, when it speaks of obligation as a juridical necessity. Okay, so obligation is a juridical necessity because, in case of non-compliance, the courts of justice may be called upon by the aggrieved party to enforce its fulfillment or, in default thereof, the economic value that it represents. So, in a proper case, the debtor or obligor may also be made liable for damages, which represents the sum of money given in a compensation for the injury or harm suffered by the creditor or obligee. So the obligee or the creditor is the one who has the right to the performance of the obligation for the violation of his rights. So, in other words, the debtor must comply with his obligation whether he or she likes it or not. Otherwise, his or her failure to be will be visited with some harmful or undesirable consequences. So if obligations were not made enforceable, then people can disregard them with impunity. There are, however, obligations that cannot be enforced because they are not recognized by law as binding. So, that's the nature of obligations under the Civil Code. So, obligations which give to the creditor or the obligee a right under the law to enforce their performance in courts or justice are known as civil obligations. So, they are to be distinguished from natural obligations, which are not being based on positive law but on equity and natural law. They do not grant a right of action to enforce their performance, although, in case of voluntary fulfillment by the debtor, the latter may not recover what has been delivered or rendered by reason thereof. So, there are now, every obligation class has essential requisites or essential elements, no? Namely, we have, for you to be able to remember it easily, so we have this PAVO. So, number one, passive subject, or the obligor or the debtor. So, this is the person who has the duty of giving, doing or not doing. This is the person that is bound to the fulfillment of the obligation. Then we have the active subject, which is also called obligee or the creditor. This is the person, either natural or juridical, who is entitled to demand the fulfillment of the obligation. So, meaning, this is the person who has the right, no? Then we have the vinculum juris or the legal tie, which is also called the efficient cause, that which binds or connects the parties to the obligation. So, the efficient cause or the juridical tie between two subjects by reason of which the debtor is bound or in favor of the creditor to perform the obligation. So, it can be established by various sources of obligations. It should be by law, by bilateral acts like contracts that gives rise to an obligation that is stipulated therein. And we have unilateral acts such as delicts and quasi-delicts. Then we have object or the subject matter. This is the prestation or the conduct which has to be observed by the debtor or obligor. Note that without the prestation clause or the subject matter, there is nothing to perform. Now, for an object to be valid, it must be, so naagihapoy, ang singanin, acronym, no, para mas ma-remember ninyo, we have hit it lipodem. So, it must be licit, it must be real or possible, it must be determinate or determinable, and it must be within the commerce of men. So, meaning susceptible of appropriation and transmissible from one person to another. Now, example. Para mas masabta ninyo. Under a building contract, X bound himself to build a house for Y for 1 million pesos. So, we need to identify here the elements of obligation. So, here, X is the passive subject. Y is the active subject. The building of the house is the object or the prestation. And the agreement or the contract, which is the source of obligation, is the juridical tie. Now, suppose X had already constructed a house and it was the agreement that Y would pay X after the construction is finished, then X becomes the active subject and Y becomes the passive subject. No? So you take note of this example, class. Let's go to forms of obligations. Now, the form of an obligation refers to the manner in which an obligation is manifested or incurred. So it could be oral or in writing, or partly oral or partly in writing. Take note that as a general rule, the law does not require any form for obligations arising from contracts for their validity or binding force. Obligations arising from other sources do not have any form at all. You take note of this. Let's distinguish an obligations, right and wrong. So, an obligation, this is the act or performance which the law will enforce. Right, on the other hand, is the power which a person has under the law to demand from another any prestation. A wrong or a cause of action, this is according to its legal meaning. So, is an act or omission of one party in violation of a legal right or rights. So, this is recognized by law. The right of another. Now, in law, the term injury is also used to refer wrongful violation of the legal right of another. Now, note that there are essential elements of a legal wrong or injury. So, what are these? Number one, a legal right in favor of a person or a creditor, obligee, or the plaintiff. Next, a correlative legal obligation on the part of another. Kinsa may na ay correlative legal obligation, it's the debtor or obligor or defendant. So, iyahang obligation to respect or not to violate the right of the other person. And an act or omission by the latter in violation of said right with resulting injury or damage to the former. Now, an obligation on the part of a person cannot exist, class, without a corresponding right in favor of another and vice versa. So, a wrong or cause of action only arises at the moment a right has been transgressed or violated. So, we have here an example. So, in our preceding example ganina, katong X bound himself to build a house for Y. Y has the legal right to have his house constructed by X, who has the correlative legal obligation to build the house of Y under their contract. So X has the right to be paid the agreed compensation, which is 1 million, provided of course the house is built according to the terms and conditions of the contract. Take note that the failure of either party, either X or Y, to comply with such terms and conditions gives the other a cause of action for the enforcement of his right and or recovery or indemnity for the loss or damage caused to him for the violation of his right. Okay? Now, let's talk about kinds of obligations according to subject matter. So, from the viewpoint of the subject matter, obligation may either be real or personal. So, when we say real, this is an obligation to give. Is that in which the subject matter is a thing which the obligor must deliver to the obligee. Now, example, X, the seller binds himself to deliver a piano to Y. So, Y here is the buyer. So, na siya obligation to give, no? To deliver the piano to Y. Next is personal obligation. So, this is an obligation to do or not to do. This which the subject matter is an act to be done or not to be done. There are two kinds of personal obligation. We have the positive personal obligation or obligation to do or to render service. So, example, X bind himself to repair the piano of Y. And then the negative personal obligation is the obligation not to do, which of course naturally includes obligations not to give. Okay, take note of that, class. Let's proceed to source of obligations under article 1157 rather. So obligations arise from law, from contracts, quasi-contracts, acts or omissions punished by law or what we call delicts, and quasi-delicts. Now take note, class, that this list is exclusive. No? Law, contracts, quasi-contracts, acts or omissions punished by law or delicts, and quasi-delicts. So let's talk about law first. No? This Article 1158. So, obligations arise when imposed by law itself, and take note, it cannot be presumed. Only those expressly determined in this code, in this Article 1158, or in special laws are determinable and shall be regulated by the precepts of law which establishes them, and as to what has not been foreseen by the provisions of this book. Article 1158 class refers to the legal obligations or obligations arising from law. They are not presumed because they are considered a burden upon the obligor or the debtor. No? So they are the exception, not the rule. So to be demandable, they must be clearly set forth in the law. Now, once the act or facts exist, the obligations arising therefrom by virtue of the express provisions of the law are entirely independent of the agreement of the parties. Take note, it must be expressly or impliedly set forth and cannot be presumed. So, example, obligation to pay taxes and obligation to support one family. Therefore, an employer class has no obligation to furnish free legal assistance to his employees because no law requires for this. And therefore, an employee may not recover from his employer the amount he may have paid a lawyer hired by him to recover damages caused to said employee by a stranger or strangers while in the performance of his duties. So this is in the case of De La Cruz versus Northern Theatrical Enterprises. Another is a private school has no legal obligation to provide clothing allowance to its teachers because there is no law which imposes this obligation upon schools. But the person who wins money in gambling has the duty to return his winnings to the loser. This obligation is provided by law under Article 2014. No? This talks about illegal gambling, which refers to which states that no action can be maintained by the winner for the collection of that he has won what he has won in a game of chance. So, under Article 1158 class, special laws refer to all other laws not contained in the Civil Code. And examples of such laws are Corporation Code, Negotiable Instruments Law, Insurance Code, National Internal Revenue Code, Revised Penal Code, and Labor Code. Let's proceed to the other sources of obligation, contracts, or the obligation ex contracto. Now, the obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. So that's Article 1159. Parties may take note, parties may freely enter into any stipulations provided they are not contrary to law, morals, good customs, public order, and public policy. Kay, sa contract manggod class, mao manggod ni sila ang mga stipulations no sa parties. This would be the law between the parties, no? Valid and binding. Binding ra na siya sa parties, wala labot ang strangers. They can freely enter into whatever stipulations, basta dili lang siya contrary to law, morals, good customs, public order, and public policy. Example, the obligation to repay a loan or indebtedness by virtue of an agreement. Now, the terms of the contracts class determines the respective obligations of the parties. So if the terms of the contract are clear and it leave no doubt upon the contracting party's intention, such terms should be applied in their literal meaning. No? So neither party may unilaterally evade his obligations in a contract unless the contract authorizes it or the other party assents. Now, this speaks of contractual obligations or obligations arising from contracts or voluntary agreements. It presupposes that the contracts entered into are of course valid and enforceable. So meaning they are able to be imposed so that it must be complied with. So a contract, although we are going to discuss that more pag-abot nato sa contract, no? So a contract is a meeting of minds between two or more persons whereby one binds himself with respect to the other, so to give something or to render some service. Now, its binding force, the obligation arising from contracts have the force of law between the contracting parties. This is what I mentioned earlier nga maunay mag-bind nila, maunay balaod sa parties. They have the same binding effect of obligations imposed by law. This does not mean, however, of course, that contract is superior to the law. So, as a source of enforceable obligation, contract must be valid and it cannot be valid if it is against the law. Ingon na taganina na the parties are free to stipulate basta lang dili siya contrary to law, public morals, public policies, and so on. So, contract is valid. So, assuming all the essential elements are present under Article 1318. If it is not contrary to law, morals, good customs, public order, and public policy. Take note that it is invalid or void if it is contrary to law, morals, good customs, public order, and public policy. Now, in the eyes of the law, a void contract does not exist. Consequently, no obligations will arise because the contract is void. A contract may be valid but it cannot be enforced. No? So this is true in the case of unenforceable contracts. Again, moabot rataan na inigabot na to sa topic sa contract. Then, breach of contract. So, a contract may be breached or violated by a party in whole or in part. Okay, so a breach of contract takes place when a party fails or refuses to comply without legal reasons or justifications with uh, the obligation under the contract as promised. Now, we have this term compliance in good faith. Compliance in good faith means uh, performance in accordance with the stipulations or terms of the contract or agreement. So, sincerity and honesty must be observed to prevent one party from taking unfair advantage over the other. Non-compliance by a party with its legitimate obligations after receiving the benefits of a contract would constitute unjust enrichment on his part. Now, although a contract provides no penalty for its violation, take note that the party cannot breach it with impunity. The oppressed party is afforded remedies to protect his rights. That's in Article 1191. So we have their examples. No? Okay. If S agrees to sell his house to B and B agrees to buy the house of S voluntarily and willingly, then they are bound to the terms of their contract, and neither party may, upon his own will and without any justifiable reason, withdraw from the contract or escape from his obligations thereunder. That which is agreed upon in the contract is the law between S and B and must be complied with in good faith. Another, a contract whereby S will kill B in consideration of 1,000 to be paid by C is void and non-existent because killing a person is contrary to law. Likewise, an agreement whereby S will render domestic service gratuitously until his loan to be is paid is void as being contrary to law and morals. And in both cases, no, S has no obligation to comply with his agreements. So you take note of this, class. Then we have another source is the quasi contracts or the obligation ex quasi contracto. Now, a quasi contract is that juridical relations resulting from lawful voluntary and unilateral acts, which has for its purpose the payment of indemnity to the end that no one shall be unjustly enriched or benefited at the expense of another. In a sense, these obligations may be considered as arising from law. When we say quasi class, this is the Latin for as if. So, meaning almost alike but not perfectly alike. So, you take note of that one. Example is an obligation to return money paid by mistake. Kana mo na example sa quasi contract. Okay. From the word quasi class, no, it is not properly a contract at all. Okay, unsa toy elements of contract? There is a meeting of the minds or consent. So here, the parties must have deliberately entered into a formal agreement. In a quasi-contract class, there is no consent, but the same is applied by fiction of law. So in other words, the law considers the parties as having entered into a contract, although they have not actually done so, and irrespective of their intention to prevent injustice or the unjust enrichment of a person at the expense of another. Let's distinguish it from other sources. So, the act giving rise to a quasi-contract must be lawful, distinguishing it from delict. Then the act must be unilateral, distinguishing it from contract, which is based on agreement. And the act must be voluntary, distinguishing it from a quasi-delict, which is based on fault or negligence. Now, there are two types of quasi-contract. Okay, so we have negotiorum histio. This number one. This is a voluntary agreement of the property or affairs of another in times of emergency without the owner's authority. So the obligation created here is to return of the property by the officious manager, no, to the owner once the emergency ceases, and for the owner to reimburse expenses incurred by the officious manager. Now, we have here an example. X went to Baguio with his family without leaving somebody to look for after their house in Manila. While in Baguio, a fire broke out near the house of X. So through the effort of Y, a neighbor, the house of X was saved from being burned. So Y, however, incurred expenses. Now in this case, X has the obligation to reimburse Y for the said expenses, although he did not actually give his consent to the act of Y in saving his house on the principle of quasi-contract. So, dili siya pwede mo ingon si X nga, wa man ka na sugua. No? So, inga na ha, sa negosyorum histio, voluntary management of the property. However, the one who do something needs to be reimbursed, no? Otherwise, he would be unjustly enriched, no? Now, okay, next is solutio indebiti. So this is the juridical relation which is created when something is received when there is no right to demand it and it was unduly delivered through mistake. So this is found in Article 2154. So it is based on the principle that no one shall enrich himself unjustly at the expense of another. Now, there are requisites, no, for solutio indebiti. Number one, there is no legal right to receive the thing being delivered, and the thing was delivered through mistake. So, the obligation that was created is the recipient or ang nakadawat is to return the property delivered through mistake. So, we have your example. DOC 1,000. If D paid T, believing that T was authorized to receive payment for C, the obligation to return on the part of T arises. No? So, if D paid C 2,000 by mistake, kay, di ba, 1,000 ang utang, C must return the excess of 1,000. The presumption, however, is that money paid by one to another was due to the latter unless the payer proves otherwise. Now, note class that the Civil Code provides the above mentioned enumeration, no, of the quasi-contract, solutio indebiti and negotiorum histio, but the list is not exclusive and it merely provides example. You take note of that. Now, there are other cases of quasi-contracts. Kay lagi dili man siya exclusive. They are provided in Articles 2164 to 2175 of the Civil Code. The cases that have been classified as quasi-contracts are of infinite variety, and when for some reason recovery cannot be had on a true contract, recovery may be allowed on the basis of quasi-contract. So, example, S, seller of goat's milk, leaves milk at the house of B each morning. So B uses the milk and places the empty bottles on the porch. So after 1 week, S asks payment for the milk delivered. So here, class, there is an implied contract, no? And it is understood to have been entered into by the very acts of S and B, creating an obligation on the part of B to pay the reasonable value of the milk. Otherwise, B would be unjustly benefited at the expense of S. So, dili siya pwede mo ingon nga, uy, man ko kay bawaan na, nga baligya di ay ito. No? So, there is an implied contract. So, kinahanglang mo bayad si S, si B, ni adto ni S. Let's distinguish solutio indebiti versus natural obligation. Now, in natural obligations, the person making the payment or delivery knows that he has no legal obligations to pay or to deliver, but still voluntarily makes such payment or delivery. For this reason, once payment or delivery has been made, there is no right to ask for the return. In Solusyo Indemnity, the payment or delivery is made on the basis of a mistake. Hence, the recipient has a legal obligation to return the object being received. You take note of this distinction, class. Okay, another source of an obligation is delict, or an act which is punishable by law. No? When they arise from civil liability, which is in the consequence of a criminal offense. So, every person criminally liable for a felony is also civilly liable. Monay atong balaod, class. Such civil liability is a necessary consequence of criminal responsibility and is to be declared and generally enforced in the criminal proceeding, except where the injured party reserves his right to avail himself of it in a distinct civil action, or in cases where an independent civil action is allowed by law. So, example, the obligation of a thief to return the car stolen from him, or the duty of a killer to indemnify the heirs of his victim. Now, responsibility for fault or negligence under a quasi-delict class is entirely separate and distinct from the civil liability arising from negligence under the revised penal code. But the plaintiff, take note, the plaintiff cannot recover damages twice for the same act or omission of the defendant. So, civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177 and of other pertinent provisions, no, of Chapter 2 Preliminary Title on Human Relations, and of course of Title 18 of this book, which regulates damages. Now, let's talk about civil liability arising from crimes or delicts. Okay, so we have here civil liability in addition to criminal liability. The principle on this class is the commission of a crime may result in both moral wrongdoing and material harm. So, from this principle, the rule has been established that every person criminally liable for an act or omission is also civilly liable for damages suffered by the aggrieved party. Now, the legal basis of this one is the Article 100 of the Revised Penal Code. So, example, if a person physically assaults someone, no, mangulata siya, they can be prosecuted criminally and may also be required to pay for medical expenses, lost wages, or other damages. Take note of that. Then we have criminal liability without civil liability. So, here in crimes, there some crimes do not result in material damage, no? So like contempt, insults to person in authority, gambling, violations of traffic regulations, etc. So there is no civil liability to be enforced. So the offender can be criminally liable, but there is no civil liability. Now, example, ana again, contempt of court, insults to public officials, so walay civil liability, ana, only criminal liability. Then we have civil liability without criminal liability. So, a person may cause harm or breach obligations without committing a crime. So, naay civil liability but walay criminal liability. The implication would be the person could be civilly liable even if not criminally responsible. Like, for example, failure to pay contractual debts, causing property damage without malicious intent or negligence. So, walay criminal intent, no? And obligations arising from quasi-delicts or acts causing damage, again, without criminal intent. Now let's talk about its scope of civil liability. No? So we have, the extent of the civil liability for damages arising from crimes is governed by the revised penal code and the civil code. So the civil liability includes restitution, reparation for damage caused, um, indemnity for consequential damages. No? So example, X stole a car of Y. So if X is convicted, the court will order X either to return the car or to pay its value if it was lost or destroyed, or to pay for any damage caused to the car and to pay such damages suffered by Y as a consequence of the crime. So, when a person is civilly liable, take note, the law provides for three main forms of reparation or compensation. Either restitution. So restitution, when we say restitution class, this is restoring to the victim the thing or property taken or damaged. No? So unsa may purpose ani? To return the victim to the state they were in before the wrongful act. So an example of that one is the returning of the stolen money or property. With regards to reparation for damage caused, reparation means compensating the victim for the direct loss or injury resulting from the wrongful act. So, what is its purpose? To cover actual material harm suffered by the victim. So, example is when, like paying for medical expenses after an assault or repairing a damaged car. With regards to indemnity for consequential damages, so this is compensation for indirect or consequential damages. So, kung sa reparation, compensation for direct loss, ang consequential damages or indemnity for consequential damages is indirect, no? Indirect damages that result from the wrongful act. Now, what is its purpose? This is to cover losses that are not the immediate result of the act, but of course, reasonably linked to it. So, on sa may example, ana, the lost income because an injured person could not work, or expenses incurred due to delayed delivery caused by property damage. So, you take note of these three: restitution, reparation of damage for damage caused, and indemnity for consequential damages. Now, okay, so let's talk about the effect of acquittal in criminal case. So, general rule, the acquittal of the accused in a criminal case due to the prosecution's failure to prove guilt beyond reasonable doubt does not prejudice the civil action, in which the offended party may still be able to recover damages by a mere preponderance of evidence. So, ingani mong gani klasa, criminal case mong god, ang kinahanglan nga ma-prove nimo sa defendant is guilt beyond reasonable doubt, while in civil cases only mere preponderance of evidence. So mo nang bisan pag ma-acquit siya sa criminal case, dili ma-prejudice ang civil action. So pwede gihapon siya babayron sa civil liability niya, except where the judgment of acquittal contained a declaration that no negligence can be attributed to the accused and that the fact from which the civil action might arise did not exist. So, moro ginaiyahang exception. Now, let's talk about the extinguishment of liability. The civil liability for crimes is extinguished by the same causes provided by the Civil Code for the extinguishment of other obligations. That's under Rules of Civil Procedures, Rule 4, Section 4. Note that the death of the accused during the pendency of the case can extinguish the civil liability if the same arose directly from the crime committed. However, this does not apply if civil liability can be based on another source of obligations. Okay? Take note of that. Next source of obligation is quasi-delict or torts. No? So, quasi-delict is an act or omission arising from fault or negligence which causes damage to another, there being no pre-existing contractual relations between the parties. Now, there are requisites of quasi-delict. Number one, there must be an act or omission. There must be fault or negligence. There must be damage caused. And there must be a direct relation or connection of cause and effect between the act or omission, the act or omission and the damage, and there is no pre-existing contractual relations between the parties. This provision class from 1162 treats of obligations arising from quasi delicts or torts. Example, while playing basketball with his friends, X broke the window glass of Y, his neighbor. The accident would have not happened had they played a little farther from the house of Y. So, in this case, X is under the obligation to pay damage caused to Y by his act, although there is no pre-existing contractual relations between them, because he is guilty of mere fault or negligence without criminal intent. No? Take note of that. So, let's talk about negligence. Negligence is a failure to observe for the protection of the interest of another person that degree of care with precaution and vigilance which the circumstances justly demand, whereby such other person suffers injury. Now, there is a test of negligence. Would a prudent man, in the position of a person to whom negligence is attributed, foresee harm to the person injured as a reasonable consequence of the court about to be pursued? Now, this is in the case of Picard versus Smith. Now, we have here example para masabtan. The obligations of the head of the family that lives in a building or a part thereof to answer for damages caused by things thrown or falling from the same. Then the obligation of the possessor of animal to pay for damage which it may have caused. For example, in jog iro, no, nakapaak. So, you have the obligation na imong patambalan or pa-injekan og anti-rabies ang naapaakan sa imong iro. Note class that there is no obligation as defined in under Article 1156 if its source is not any of those enumerated in Article 1157. So, when we talk of quasi-delict as a cause of action despite a pre-existing contractual relation. Now, general rule, actions based on breach of contract and actions based on quasi-delicts differ in terms of conditions, defenses, and proof. They cannot coexist. You take note of that. Except when a contractual relations exists, the obligor may break the contract. The same act which constitute a breach of the contract would have constituted the source of an extra contractual obligation had no contract existed between the parties, and if the act that breaks the contract may also be a tort. Now, note that when an obligation is based on a contract without which the obligation does not exist, the cause of action must be founded on the breach of contract and cannot be based on quasi-delict. Okay? So, in the case of Air France versus Carrascoso, no? A 1966 case. Air France was punished by the company's racist policy, which emboldened the manager to expel the Filipino from first class because a white man had a better right to the seat. So, Air France would apply if the act which breaches a contract was done in bad faith and amounts to a violation of Article 21 of the Civil Code. So, atong i-distinguish class and crimes from quasi-delict. Okay. The following are the distinctions. In crime, there is criminal or malicious intent or criminal negligence, while in quasi-delict, there is only negligence. In crime, the purpose is punishment, while in quasi-delict, it's only indemnification of the offended party. Crimes affects public interest, maunang ang sa kaso Republic of the Philippines versus, no? While quasi-delict concerns only private interest. In crime, there are general two liabilities, the criminal and the civil liabilities, while in quasi-delict, there is only civil liability. Criminal liability cannot be compromised or settled by parties themselves, while the liability for quasi-delict can be compromised as any other liability. And in case, or rather in crime, the guilt of the accused must be proved beyond reasonable doubt, while in quasi-delict, the fault or negligence of the defendant need only proven by preponderance, no, like superior or greater weight of evidence. Now, you take note of that class. Again, sa criminal cases or sa crime, it must be proved beyond reasonable doubt. So meaning, the evidence must be very clear and convincing, as well as engender belief in an unprejudiced mind that the guilty or that the accused is really guilty. So now let's classify the sources. Diba, we have law, and sa to, contracts, quasi-contracts, acts or omission punished by law or delicts, and quasi-delicts. Now let's classify these. While the law enumerates five sources of obligations, they may be classified as follows: as those emanating from law and those emanating from private acts, which may be further subdivided into those arising from legit acts or licit acts, lawful acts in case of contracts and quasi-contracts, and those arising from illicit acts or unlawful acts, which may be either punishable in the case of delicts or crimes, or not punishable in the case of quasi-delicts or torts. So therefore, class, there are only two sources of obligations, law and contracts. Because obligations arising from quasi-contracts, delicts, and quasi-delicts are really imposed by law. Okay? You take note of that, my dear students. Thank you for listening. Let's continue with our discussion on Article 1163. No? Bye.